Lords, there's one point I would pick up from this morning where I failed to give my Lords a reference, and that's to a passage in the judgment of Mr. Justice Buckley in the Spenborough case, which is behind tab 9 in the authorities bundle, starting at page 332. The passage I wish to draw the Lord's attention to is at 344, starting at D, where Justice Buckley observes that approaching the problem before me is one of construction to be determined in accordance with the ordinary principles applicable to such a question without leaning one way or the other. He then has regard to certain circumstances. And if one turns over the page at F and G, we see what he said there about what was not commercially sensible. If at this point I pause to ask myself whether in the light of these circumstances it's commercially sensible to suppose either that the corporation, when it entered into the 1951 agreement, intended to assume obligations to which it would have no power to put an end except on breach by the defendant, or that the defendant, when it entered into the agreement, thought that the corporation intended to assume such obligations, I think the answer should be no. Before the short adjournment, I took the Lords to the Proactive Sports Management and Rooney case in relation to the significance of commercial success under the agreement to date. There are three further points which I would note in relation to the impact of the restraint, or the proper characterization of the restraint. First, it's necessary to look at the substance of the matter rather than to its form. Second, it's necessary to consider the effect of the terms of an agreement in combination as well as separately. And third, it's necessary to assume that the relevant provisions will be enforced to the full extent and rigour of their terms. So far as the first of those propositions is concerned, the case which is generally cited for it is the Stenhouse case in the Privy Council. One finds that in the first bundle at tab 10, starting at page 348. Dispute in that case was between an insurance broker and its former employee. The impugned provision related to the treatment of any commission earned by the former employee on business directly or indirectly affected by him with clients of the brokerage after he had left the brokerage. The relevant provision one finds at page 359F. It's clause 5, which is said to be a stipulation of a different character. And the key passage dealing with it bridges 359 and 360, starting at 359H. The clause in question here contains no direct covenant to abstain from any kind of competition or business. But the question to be answered is whether, in effect, it is likely to cause the employee to refuse business which otherwise he would take, or looking at it another way, whether the existence of this provision would diminish his prospects of employment. And then in the passage of the judgment following, one sees consideration given to the impact of the provision which required that 50% of the commission be handed over to the brokerage.
How does that test bite in this case?
The provisions in this case are not in terms, don't share profits. What they do is diminish the ways in which the company can, as a matter of substance, conduct its business. So I've addressed my lords, for example, on the question of how the combination of the royalty provisions and the definition of licensed services may serve as a poison pill against the acquisition of businesses or the merger of business.
What's the evidence of that? The test that you've just taken to us is likely to cause. I mean, one might, seems to me, with equal merit or lack of merit, say that it doesn't diminish their business abilities, it enhances them to have this association. So how does that test sound on the evidence that exists in this case?
First of all, the matter is to be tested as at the date of the agreement.
Well, even more so then.
Yes. Such things are, at least ordinarily, and that's obviously something I'm saying without giving evidence, assessed without expert evidence, but by reference to the nature of the provisions. And the reason why one can say that quite comfortably in this case is because the restraint one is looking for is not a restraint which needs to be proven to prevent the business being conducted successfully. It's a constraint on the ways in which the business may be conducted. It's a restraint on the freedom of the party to act as they choose. And one can see that it is a restraint on the freedom of the party to act as they choose if the consequence of their choosing one particular course will have an obviously adverse financial effect. So in this case, if one looks at, for example, the poison pill consideration, if one is to be free to choose to merge or to acquire another business, for that to be meaningful, it cannot be that you can only do it at the expense of rendering all the business conducted by the company with which you would merge liable to royalties under this agreement. So I would accept there may be some situations in which it is appropriate or necessary to have evidence to assess the impact of the restraint we identify. But on the facts of this case, I believe as a matter of ordinary course, one looks to the clauses and can see that it would have an impact on the range of choices available to a party, even if that is a range which includes some courses which could still be perfectly sensibly and profitably pursued. So I was dealing with the first of the three further points I was making in relation to the approach to restraint. It's a matter of substance. What the effect, looking at the clauses, may be seen to be calculated to be. The second is that one looks to the, or can look where appropriate, to the combination of terms rather than any individual terms. And in support of that, I would go to the McKillistrim and Ballymacallicott Cooperative Society case, which is in the first volume of the authorities behind tab 3 at page 70. This is a House of Lords decision It concerns a cooperative society agreement and the obligation on dairymen, members of the society, to sell their milk to the society creamery. The relevant clauses are set out in the speech of Lord Birkenhead at page 81. Sees there set out clauses 6, 2, 3, 16 and 21. Which deal with the obligation on members to sell their milk to the society, and then on the circumstances in which members can withdraw from the society. It is the combined effect of these clauses then the focus of Lord Birkenhead's analysis, and one sees that if one turns on to pages 87 and 88, in the middle of page 87, having looked at the clauses some 15 lines down, he states, the result is that an unwilling member is likely to find himself precluded for life from disposing of the raw material of his trade to anyone but the respondents, with the exception already noted within a radius, etc. And at 88, in the last paragraph of the Lord Chancellor's speech, it is therefore necessary to ask plainly whether it can be reasonably necessary for the protection of the resemblance of the respondents to tie the appellants for life unless the committee thinks fit to grant him a dispensation. I'm clearly of opinion that it is not and cannot be so necessary. I'm further of opinion that these three rules read together are bad as being in restraint of trade and not reasonable as between the parties. And Lord Finlay approaches the matter in essentially the same way at the bottom of page 90. There's nothing unreasonable in the provision that the consent of the committee is necessary for a transfer of shares, but this provision, reasonable in itself, has a most important effect upon the scope and operation of Rule 6.2. A member cannot cease to be a member except by getting rid of his shares, and if the committee refuses to give their consent, the member remains subject to the operation of Rule 6.2 and is forbidden to supply milk to any creamery other than the creamery of the society, or to any company, society, person or person who sells milk or manufactures butter for sale. And he describes that as a sweeping interference. So that's the third of these three propositions. Sorry, second of these three propositions. The third, in fact, one also gets from the McAllistrom case as to the need to assume the relevant provision will be enforced to its full rigour and its extent. It seems as a practical matter, the committee of the society consented to members transferring their shares and withdrawing from the society. So the mischief focused on had not, at least in other cases, materialized as a practical problem. However, if one turns to the speech of Lord Shaw at page 110, in the paragraph beginning "My Lords," about 2/3 of the way down the page, so I should be the last to question that the rules were framed with a praiseworthy intent, etc., etc. But we are in the region of contract, and the sole question for the consideration of the House is whether the new rules, which I have thus briefly sketched, do or do not form an invasion of that system of contract beyond the point which public policy will sanction. In order to test this question, and no less test can be satisfactory, it is necessary to assume that these rules may be put in force against the appellant the full extent and rigour of their terms. Lord, having identified those principles, I then turn to the restraints in this case and then to their application in accordance with the guidance one gets
Before we
from
leave the cases, Mr.
quantum actuarial case.
Yeah. And just before we leave the cases, is there any learning on how you identify what the solution is if you identify a restraint of trade? And let me put the point to you. It occurred to me as you were referring to your poison pill point that might be an unenforceable restraint of trade. It doesn't require a termination clause to remedy it. It's just unenforceable, if you're right.
My Lord, I see the strength of the observation. How that would work in practice when what renders this a poison pill is the scope of the activities attracting a royalty is difficult to address.
Okay.
Given the court can't really vary the royalty, and I think would have some hesitation in rewriting the definition of licensed services.
You just take out the bit that says group companies have to be bound, that's all. Your poison pill point, as I understand it, is a very particular point. You say that a company that took you over would have to start changing its name to Zaha Hadid. That's your poison pill. And the answer to that could be that the bit of the clause that says that is an unenforceable restraint of trade.
It's not just that it would need to change its name, and that depends on how one interprets the other clauses in the agreement, but that regardless of what his name was and regardless of what brands it was operating under, it would have to pay royalties. So one would be deleting from the consideration royalties in respect of all but the company. That is obviously a possibility, but in that context, the court would no doubt need to address the question of whether or not it could do that without so changing the agreement as to go beyond the ways in which you can cure unenforceability.
Okay.
It is an option, my lord, but it would very much depend on quite how one construed what one found to be the mischief and the extent of it. But whether or not there are such mischiefs, one starts, we say, by distinguishing two questions. The question of what the effect of the impugned clauses in this case may be, and the question whether such an effect is of any relevance from a restraint of trade perspective.
Is it maybe or likely to be?
It's not likely to be in the sense that there is a burden to show that there is a certain probability. So it is maybe, but in saying that it is maybe, plainly it's, if it is regarded as not being a serious possibility.
It's the sort of real possibility that cannot sensibly be ignored type of...
Yes, precisely. So I seek to distinguish two questions. The question of what the effect of the impugned clause is, and the question whether any such an effect is of any relevance. The license agreement expressly prevented the company from becoming affiliated with any other business. We submit that such a restriction would operate, which operated in perpetuity, would be a serious interference with the ability of the company to conduct its business as it chooses. If such an express provision is capable of engaging the doctrine, then so should a clause that is calculated to have the same effect. Similarly, one supposes the agreement stated expressly that you shall forever conduct your business and procure that your affiliates conduct their businesses in accordance with the directions of whoever the licensor from time to time may be. We would submit that a requirement to submit the operation of one's business to such direction of third parties who could be competitors, is the very antithesis of freedom of trade as one chooses. And third, were the agreement to state expressly that the company must use its best endeavours to maximise its business and that of its affiliates every year in perpetuity, regardless of whether it judged this is most profitable and appropriate course for it to follow, that again is a clear interference with its ability to conduct its business as it chooses, and we say, of course, a fair characterisation of the consequences of clause 5.1.
Well, you add the words in perpetuity, but this
Yes.
argument doesn't depend upon the length of the agreement at all, does it? You're just saying that's a feature of the agreement.
But Lord, as long as there is the option of escaping it, it may be regarded as a part of a financial bargain that might reasonably be accepted. It may not be a well-drafted one, may be some respects in which, on any view, the restraint goes beyond that which is defensible, having regard to the legitimate interests of a licensor. But in a sense, I don't need to go that far. All I need to show is that that combination, those clauses in combination with an inability to terminate the agreement gives rise to an unacceptable interference. The interference with our ability to conduct our business, even if the agreement is terminable, is, as it were, the type of restraint which might be said to be involved in any commitment that one makes contractually, which precludes one from acting in other ways. We don't concede that, but we don't need to fight on that ground.
Does this argument depend on what, in fact, the period of reasonable notice would be if it existed?
There may be situations.
No, forgive me, it doesn't. That's a bad thought.
I mean, the only circumstance in which perhaps, apologies if I'm following up a point that I shouldn't have followed up, but if there were a major capital commitment, one can imagine circumstances in which one would have to take into account a considerable period of notice, but I don't think any such issue arises in this case.
I think it does follow from what you're saying that if this were the effect for 5 years, that might not be an unreasonable restraint of trade, but if it was for 30 years, it would.
Yes. And ultimately, there are judgment calls to make according to a flexible rule of reason. But happily, in this case, we're not in that area, because what we're faced with here hypothesises a situation in which we have no right to terminate at all at any time. So I don't need to address the perhaps potentially more problematic situation in which there is a right to terminate, but it may not be a sufficient one. For example, and that does arise in other cases, is one of the factors that was noted in the PSM and Rooney case. That was, I believe, a fixed term rather than an extended notice period of reasonable notice, but it was commented that it was a very considerable period of time. The same was considered in the Schroeder Publishing and Macaulay case, where the songwriter, who was unknown at the time that he entered the agreement, was committed for a considerable period of time to the publisher, regardless of whether the publisher actually published any of his works, and thereafter potentially for run-on period. So the courts have shown a willingness to look at the length of the period and judge it potentially, or judge it excessive, even if it is a limited period of time. But in this case, we're not dealing with a limited period of time, so we can say ex hypothesi. If time is relevant, perpetuity is as long as it can be. So I've addressed my lords on those 3 points which I wish to identify. On the suggestion that, well, this is really to do with promotion rather than prevention, there are 2 further citations that I would take my lords to. The first is from Petrofina. It's from the judgment of Lord Diplock, so that's bundle 1, tab 7, and the relevant passage is on page 249. This is dealing expressly with the suggestion that a clause that is intended to promote, can't act as a restraint of trade. Starting at B, Lord Justice Diplock says, the second is that the doctrine has no application to contracts intended for the promotion of trade of the parties, even though the manner selected by them for the promotion of their trade involves abandonment of other methods of promotion. I find the second contention somewhat elusive. I think that it does no more than assert that if on analysis of the effect of the contract as a whole, it's likely to promote the expansion of trade, the restriction will be found to be reasonable. But this is an application of the doctrine, not its exclusion. The second passage I'd go to is a passage from Lord Reed's speech in Esso, and whilst that is no longer the preferred approach following the Peninsula as regards those clauses which where one can dispense with any assessment of the reasonableness of a restraint. I think for these purposes, what is said there is still good law, and it's at page 286 F to G. The passage starting there, in my view, this agreement is within the scope of the doctrine of restraint of trade, as it had been developed in English law. Not only have the respondents agreed negatively not to sell other petrol, but they've agreed positively to keep this garage open for the sale of the appellant's petrol at all reasonable hours throughout the period of the tie. It was argued that this was merely regulating the respondent's trading and rather promoting than restraining his trade, but regulating a person's existing trade may be a greater restraint than prohibiting him from engaging in a new trade. My lords, the facts of these cases matter, and the facts of those cases are, of course, very different from the facts in this. But the starting point, we would suggest, is that any restraint falls to be scrutinized to some extent. The question is how you scrutinize it and when you can dispense with the need to consider the matter further. And it's with those issues in mind that one turns to what is probably now the principal authority, at least in the Court of Appeal, the quantum actuarial and quantum advisory case. which is in the second bundle of authorities behind tab 24 at page 885. The case concerns the reorganisation of 3 businesses providing pension fund services and the covenants restraining one of those businesses from poaching clients of one of the other businesses to which it was to provide services itself. The relevant part of the judgment starts at paragraph 53 at page 903. And it is important to understand the way in which this judgment is structured. This section starts under the heading "The Law." The first section at paragraph 53 cites the explanation of what is meant by the doctrine of restraint of trade in Chitty, so it's a general introduction. The second section, which is headed Application of the Doctrine, is from paragraphs 54 to 61. And it is concerned with those restraints which are unenforceable unless reasonable. The third section is headed reasonableness. That goes from paragraph 62 through 65. And then the fourth section is headed interplay between application of the doctrine and reasonableness. One now digs a little deeper into it. At 66, Justice Carr cites the observations of Justice Arden and Lord Justice Gross in the PSM and Rooney case about the overlap between the 2 stages of the exercise, and that is a reference back to the way in which the matter is formulated in earlier cases. At paragraph 67, Justice Carr refers to the fact that the judge found against the appellant in relation to both stages of the exercise, and hence what it was required for the appellant to succeed on appeal. And then she says, it is, however, convenient, start a little higher up, as indicated above, the 2 questions are not to be treated as entirely discrete. So that's the question of how you can identify those contracts where you can dispense with an assessment of reasonableness, and the question of reasonableness. They're not to be treated as entirely discrete. On the facts of the case, there is a very significant degree of overlap. It is, however, convenient to consider the threshold test first, while acknowledging this interplay. There are 3 steps to consider. So what she's identified in 16 is what she's going to go on to do, which is assess the threshold test. And it is clear that the threshold test to which she is referring is the first of the 2 stages. One sees that if one turns to what she says about ground 1 in paragraphs 70 to 72. In particular, paragraph 70, where she says, it's necessary first to consider the correct approach in law to be taken to the question of whether or not the threshold to engagement of the doctrine is crossed. So, the threshold to the engagement of the doctrine is the threshold requiring that a party who wishes the court to enforce a contract satisfy the court that it's reasonable. The three steps to which Justice Carr refers in paragraph 68 relate to the first stage and are expressly adopted as a matter of convenience. Those are her words. The judge in this case treated the three-step approach to the assessment of the threshold question in quantum actuarial as a matter of something more than convenience. If one turns to the judgment, so we're in the core bundle behind tab 7, one turns to paragraph 50, which is at page 93. The judge notes there, at the bottom of page 93, paragraph 50, in the present case, as to whether quantum advisory laid down a three-stage test or a two-stage test, determining whether a provision should be struck down as in restraint of trade. And the judge goes on in paragraph 51 on page 94 to state that this tripart classification has some importance here, as Mr. Abrams KC pointed out, because there is no obvious provision in the license agreement which operates as a restraint and so satisfies the first part of the test set out above. The judge addresses the question whether there is a restraint in the paragraphs that follow, between paragraph 51 and 69, and it's against that analysis, or following that analysis, that he then concludes that, in paragraph 67, he concludes that the relevant constraint is not a restraint of trade in any meaningful sense. That's the bottom of paragraph 67. He goes on to make the observation to which I've drawn attention in 69, just stopping us from managing a successful business in a different way. His starting point there is that there's no legally relevant restraint at all, and it's having made that determination that he then goes on to deal with the next two questions as he describes them in paragraph 70 and following. But the next two questions as he describes them are the two key questions to be answered, the two questions identified by Lady Justice Arden and identified by reference to the cases which she cites. There is no separate step to be conducted prior to that, whilst of course it is accepted that one needs to identify the nature of the contract you're dealing with in order to have any subject matter on which to focus. Why do we say this matters? The fact that the judge has adopted a tripartite approach doesn't mean that his overall conclusion is necessarily wrong. We, of course, accept that. One cannot answer the question whether a contract falls to be assessed from the perspective of reasonableness without identifying aspects of the contract. We accept that. However, what the judge appears to have done in adopting the tripartite approach that he has is to exclude certain kinds of restraint from consideration, and in particular not felt it necessary to apply the iterative process and consider reasonableness as part of the determination of whether or not one needs to look more closely at the contract as a whole, as one is taught, both from the speech of Lord Wilberforce in Esso and in the judgment of late Justice Arden in Quantum Actuarial. He's treated the restraints in this case as ones that can be, as it were, dismissed as a matter of principle without having regard to their economic consequences. Now, part of the reason for that appears to be a view as to what the relevant interests are that one has to take into account here. I noted the observation of Sir Geoffrey Voss in the Lamessa case as to the need to take account of the interests of both parties when interpreting an agreement. One has to take account of the interests of both parties in this context in a slightly different way. The interests which we are required to consider when considering restraint of trade are those inherent in the type of agreement that is at issue. If you're seeking to apply the first stage in the exercise, is this a contract of a kind where we can dispense with further analysis? You're concerned with the essential nature of the case, not with any particular characteristics attributable to the particular parties. And there are two cases which I cite in support of this, perhaps an elaboration of it. The first is the PSM case, which we've already looked at, and the second is XR Touring. PSM, that is in the first bundle of authorities behind tab 16 at page 621. You'll recall that it's a case concerning image rights, and the relevant passage is at page 656. Paragraph 150 in the judgment of Lord Justice Grose. Seventhly, the general sole agency agreements, seventhly, in general, sole agency agreements will not attract the restraint of trade doctrine, at least provided they contain no restrictions other than those necessary or incidental to the inherent nature of a sole agency. The benefits of a sole agency inevitably require giving up the opportunities of other agencies. And it's in that context which he notes that such agreements may be seen as promoting rather than restricting trade. So one looks to the character of the agreement, and it's that same approach.
Before you leave that, sorry, I see you're moving on. Just the sidebar passage, sixthly, on that page. You were making submissions earlier on about the relevance or otherwise of how the company had been doing since the agreement.
My lord,
How does the judge's treatment of that issue fall with paragraph 149?
well, the first observation is, of course, and I'm not sure whose sidebar this is, but what's happened is not relevant, save for the purpose identified there.
Yes, so it's relevant, but in a particular way.
It's relevant, but in a particular way.
I mean, I had understood, and this is probably my inattention, but I had understood you to be making a more fundamental submission, which is that whether the company done well or badly since was irrelevant. But it seemed to me, before alighting on that paragraph, that, for example, if the company had been hampered or crippled by the levy, that might very well shine some light on the parties' intentions when they made their contract. Similarly, if the company had been flying, that might also, might not, shine some light on the parties' intentions when they made their agreement.
Lord, picks me up on that very fairly, and let me see if I can put my position, our position, a little bit more precisely than I may have put it before. Obviously, if, for example, the company was manifestly struggling to perform some particular covenant, that's a consequence that could be parade in aid. At the same time, one sees from the proactive sports management case that the mere fact that the company has prospered, or the business has prospered, and that lots of money has been made, doesn't mean that the clause is a reasonable one. The starting point is that one judges it as of the date of the agreement by reference to the provisions of the agreement, having regard to the possibility that they be enforced to their full rigour and extent. And, despite, for example, in the McKillistrim case, that not being the way in which things had actually operated. I would accept that there may be some grey area as to how far and precisely how, on any particular case, the experience of the parties may shed light on the nature of the obligations as they were at the date of the agreement. But in this case, our submission is that no such complication arises, since the points to which we are highlighting in this agreement are not in themselves, are not said by us to be individually oppressive or even oppressive in combination, provided there is an opportunity to escape these obligations. And of course, if the agreement, contrary to our submission, goes on in perpetuity, it could be for an unreasonable period of time, but in this case, we have a binary choice between reasonable notice and in perpetuity. If they go on in perpetuity, what may have happened in the first 10 years of that period may be of little assistance. Indeed, we would say is of little assistance.
Thank you.
So the proactive sports management case, the passage I was seeking to draw my Lord's attention to is paragraph 150. And I do that because of the way in which the relevant interests are identified. One finds the same thing, or a similar approach, in XR touring, and that one finds in the second bundle of authorities behind tab 30 at page 48. This is a judgment of Lord Justice Bean, or he gives the main judgment, and Lord Justice Moylan and Lord Justice Phillips concur with it. The case concerns an agreement between
I
a
think there was a dissenting. Was there not? Doesn't matter.
No, well,
It says Lord Justice Moylan dissenting.
I apologise. My note is at fault there.
Yes, he would have dismissed
Yes,
it.
your Lord's absolutely correct. And it's Lord Justice Phillips who agrees with Lord Justice Bean. I'm going to focus on the judgment of Lord Justice Bean and just put it in context. The case concerns an agreement between a concert booking agency and a former employee. The passage which we rely on is paragraph 19, which is on page 1054. And this is a summary judgment case, or I think it's a summary judgment rather than strikeout. And the question was whether or not the restraint was obviously in restraint of trade. At the beginning of 19, we see Mr. Goulding's next complaint is that the judge failed to identify or consider XR's legitimate interests, which the Commission Clause sought to protect. And then there's a more detailed consideration until about, one picks it up some 9 or 10 lines from the bottom. The judge's omission to identify this legitimate interest was, with respect, an error of principle, which calls his evaluative decision into question. So one needs to identify the interests which may render the restraint reasonable. At paragraph 82 in his judgment in this case, the judge found that Dame Zaha had an obvious interest in the successful exploitation of the marks under the license agreement, and there's nothing unreasonable in her acquiring the company to show the sort of ambition inherent in the best endeavours undertaking in clause 5.1. The mischief in this case is not so much directed to that, but of course to that in combination with the inability of the company to terminate the license. What we don't have is an equivalent analysis of the legitimate interests of the company. And this appears in part to be because the judge took the things of which the company complains to be a problem of its own making. So,
Sorry, Mr. Block, forgive me if maybe I'm misunderstanding. In my simple-minded approach to this, restraints of trade, one of the things that happens in a restraint of trade case is if you found there is a restraint, a question, which I think is what is referred to by Lord Justice Bean in XR, is whether the restraint is reasonable having regard to the legitimate interest of the restraining party.
yes.
That's the legitimate interest that is referred to, I think, in para 19, and that's the legitimate interest that's referred to in the judgment at 82.
My lord, yes, but
Now, what you're moving on to, and I'm sure it's right that your client's interests are something that gets borne in mind somewhere, but they don't fit into that bit, do they? The bit that this interest is talking about is the interest said to justify the restraint.
my lord, yes, but it's an interest that's said to justify the restraint, having regard to the competing interests of the other parties, and the ultimate exercise is a balancing one.
Okay, that's, I mean, I may be right. It's not what just has been said in para 19, which is what I thought we were.
Yes.
Okay, I'm missing something. Fine, thank you.
But, my lord's of course right. It does not say there in terms, but I believe it is, and it's certainly our submission is the law, that one is having regard to the competing legitimate interests of the parties, and not simply to those of one of them. So, if I can get a better reference in relation to that, I will. What I was proposing to deal with next, and very closely finally, is what seems to have influenced the judge in dismissing the concerns of the company. And one sees that, perhaps one starts at paragraph 79 in the judgment. So there, he acknowledges that that's at page 99. He observes the evidence there was that Dame Zaha would have realised that her name had only finite value. One sees that in the middle of that page. At paragraph 80, he states that the evidence appears to suggest that if asked at the time, Dame Zaha might have been prepared to address the sort of concerns the company is raising. That is the last sentence in that paragraph. That seems to be apt to describe the case insofar as the company was empowered to negotiate for just the forms of protection it now says it needs, and which its own evidence suggests it would likely have been given had it asked for them. In paragraph 80, the judge also observes, perhaps somewhat tartly, the restraint of trade doctrine does not exist to allow parties to write into contracts terms which could have been included, but for one reason or another were overlooked. And at paragraph 82, towards the bottom of that paragraph, in support of what he has found in relation to reasonableness, he states some 6 lines up, I have already noted above the circumstances in which the license came to be executed, which again are relevant to the question of reasonableness. The outcome of negotiations between parties of equal bargaining power may be generally expected to be a reasonable outcome, as such parties may be generally expected to know what is in their interest to agree or to decline to agree. There was no negotiation in this case. The judge refers to Mr. Schumacher's evidence on this at paragraph 76. The judge attaches no significance to this at page 76, as he considered that Mr. Schumacher was not without agency and that Mr. Schumacher could be expected to represent the interests of the company. However, the reality is that there was no negotiation, and as the judge notes at paragraph 16 in his judgment, the company took no legal advice. Moreover, there's no evidence that either party actually appreciated, assuming it is the case, that there was no way that the company could terminate the license agreement. There's no evidence that either party appreciated that the definitions of licensed activities might, in combination with those of group and group companies, have the effect of which we complain.
With respect, so what? The points you've just been making don't go to inequality of bargaining power to the extent that that has any application in any event. There was an equality of bargaining power. It's simply that the company chose not to exercise the bargaining
My
power.
Lord is right, and the point that I'm making expressly puts to one side equality of bargaining power, in the sense of exercised bargaining power. The point that I'm seeking to present is a slightly different one. We know that inequality of bargaining power may affect the willingness to enforce agreements in equity. We're not in that territory. It may also be that inequality of bargaining power, insofar as it goes to fairness, can be taken into account when applying the common law doctrine of restraint of trade. What we do know, though, is that when applying the common law doctrine of restraint of trade, comfort may be taken in an appropriate case from the fact that the agreement before you is of a kind, or in a specific case, specifically been the subject of a full negotiation. Because one can, where there has been a negotiation, at least as a presumption, anticipate that the parties may have been the best judges of their own interest. But in a case in which there has been no such negotiation, that comfort simply can't arise.
Why shouldn't one assume that the parties are the best judge of what's in their own interests if they have the power to negotiate, but have simply on one side chosen not to do it?
Well, it's difficult.
We're not talking about bargaining power. That's the problem. You're talking about actual bargaining, not bargaining power. I quite understand what you say about unequal bargaining power, but what you're invoking in this case is simply an absence of bargaining where there was an equality of bargaining power. And where do we see any authority that suggests that that's relevant to the restraint of trade doctrine?
Well, insofar as we see, going back to, I can't point, my Lord, to an authority which deals expressly with the distinction that my Lord is making. But what I can do is endeavour to invoke the principles adumbrated by Lord Wilberforce in Esso, where he describes the terms of those contracts where one can dispense with the need to examine them for reasonableness, those contracts which satisfy the trading society test, as including at least those contracts which have been, I can't remember his precise phrase, but honed under the anvil of mutual negotiation.
But if you have a solus agreement, which is the type, classic type, which is accepted, does it matter whether it's actually been negotiated or not? If it has the features, which Lord Wilberforce was describing, that don't make it exceptional, whether it's been negotiated or not, simply doesn't enter into it, does it?
If it has the features of a kind of contract which is common within society, then individual contract has been negotiated won't matter, unless, of course, one is looking more closely at it because it has certain special features or exorbitant features. Now, we've already acknowledged that a trademark license, or that trademark licenses are a perfectly normal feature of the commercial world, and that absent special features or exorbitant features, one would be able to dispense with an assessment of them individually as to their reasonableness. But what we're now considering is how one does assess this particular license, where of course we say there are features which are special or exorbitant, and we've identified what they are, or how the combination of clauses within the agreement has that effect. And it's in that context and considers where one has, as in this case, a license agreement, a perfectly unexceptional type of agreement, but with certain special features which may be exceptional, how one may be assisted by whether there has been negotiation or the relative power of the parties in any such negotiation.
So does it follow that the public policy in striking down certain bargains as interfering with a person's ability to trade may operate differently to identical contracts, one of which has actually been negotiated and one of which has not?
My Lord,
I don't really see how it shouldn't. I don't see how the public policy behind this should be looking at the fact of negotiation.
well, my Lord, the reason why one looks at whether there has been any negotiation or the relative power of the parties in any such negotiation isn't in order to determine fairness, but to determine how the balance of the legitimate interest of the parties may be expected to have operated in this case. It's a way of assisting you in carrying out an assessment. So if one goes back to my Lord's observation as to whether or not one should get different outcomes in different cases in relation to the same contract, the answer will be no, unless there is some reason in which something about the character of the contracting parties which is appropriate to take into account. The general answer should be no. But the way that you go about it might be different in different cases. So in a case in which there has been a negotiation and the contract is the outcome of that negotiation, that fact may be a relevant fact to bear in mind insofar as the court will have regard to the parties' ability to judge their own best interests. So it doesn't affect the outcome in the sense of being a relevant criterion, that it may be something that you can take into account when it is present, and obviously can't take into account when it is not. And if there's been no negotiation, if all you have is a document that seems to have been drawn without great consideration, with any great thought, from some sort of standard template, and then adjusted by the lawyers for one party and simply presented to the other in circumstances where, even if they had the power of agency, they haven't exercised it, you can't, against that background, conclude that the parties have been the best judges of their own interests. But you're concerned ultimately not with whether they have been the best judges of their own interests, but what the proper balance of interests is, and the reasonableness of the restraints is, having regard to the terms of the contract. And one can illustrate that perhaps by reference to the judge's observation as to what might have happened in this case if the company had sought to put in a clearer or an express notice provision in its favour. And what the judge has said is, as we understand paragraph 80, that she might have agreed to it. The problem is, he's saying, you simply overlooked it. Well, if one's being sort of judgmental about it, that may well be a way of viewing what happened. But the more important perspective, we would say, is this. If the judge has concluded that she might well have agreed to a reasonable notice clause, it's hard to conclude that that there being no basis on which the company can terminate the license is necessary to protect her legitimate interests. Her legitimate interest does not extend to holding the company to the contract in perpetuity, and were it to do so, one wouldn't have contemplated that she would have conceded it. So, my lord, one of the difficult things in relation to the presentation of a case in relation to restraint of trade, we are taught that there is no clear definition. We know that at each stage you have to take into account the factors which come more into the fore at other stages, and we are taught that each case one has to focus very much on its particular facts, whilst at the same time having regard to the type of agreement that is at issue. What we say distinguishes this case, and clearly distinguishes it, isn't that it's a trademark license. It is exorbitant and has a special feature insofar as what might otherwise be regarded as acceptable obligations are obligations to which we're tied in perpetuity.
Mr. Lord, thank you. That way of putting it isn't something I'm sure this is what your case has always been, but I hadn't ever heard it, at least in the way that the penny dropped with me quite so well as I just have. And that causes me to ask you this question. On what basis is the court to decide whether the clauses you're complaining about are exorbitant relative to a normal trademark license? I hope you're not relying on me on the basis that you think I've done lots of cases about trademark licenses over the last 10 years, because that would be a very unsafe way.
I'd prefer to endeavour to rely on my lord than to advance my own experience. There is, of course, no expert evidence on this. I don't believe it's a problem for me for this reason. We submit that the agreement taken as a whole is in restraint of trade, and that there is no proper basis on which the foundation can identify interests that could justify it. In presenting the case as I just did in summary, I was conceding something which strictly is from a learned friend to make good, which is that that a license agreement, and this is a license agreement, is of itself absent exorbitant or special circumstances, an acceptable part of trading society. But to see that the things which we say are exorbitant or special in this case are exorbitant or special, you don't need to know that they don't crop up elsewhere. You can see that the effect here is of a kind which, in any agreement, whether it's a license agreement or any other, would create special circumstances and special problems.
Well, that's what worries me, because I'm sitting here thinking, I'm sure trademark licenses I have seen contain best endeavours clauses.
Yes.
So what am I to do? Because you tell me it's an exorbitant clause.
No, my
and
lord,
I'm
I don't.
thinking,
I apologise.
It doesn't feel very exorbitant at the level of.
My lord, I do not say that a best endeavours clause is exorbitant. I do not say that a clause requiring one to take direction from the licensor is exorbitant in itself.
Right.
Our case only arises if you're against us on construction in relation to the termination clause, and it is only focused on the combination of those clauses, of the other clauses of the agreement, clause 5 and the other ones that we've looked at, in combination with the absence of any basis on which to terminate it. So the individual clauses taken individually, I mean, there are those that might be criticised, but that's not the thrust of our case.
So one could, is this right, one could delete your references to being one-sided or operating so as to cause difficulty for your clients, because those aren't features absent perpetuity which could attract the doctrine. It is simply that they do impose burdens on you and that you don't have any chance to escape them forever.
My lord,
Analytically, is that what it amounts to?
I apologise if this sounds slightly ingenious, but it rather depends what you mean by analytically. By that, let me endeavour to explain. In a sense, of course, I agree with my lord that the principal thing of which we object here is those features of a trademark licence which one might expect to see elsewhere, and the inability to escape it. At the same time, since we are taught that in this field one is applying a broad rule of reason, I hesitate to say that the burdensome or one-sided nature of the clauses taken together, if that's the view the court takes, shouldn't weigh in the balance. Analytically, we don't require it to present the principal case we're presenting, but at the same time, it is, insofar as we can make it good, part of the case that the court may think appropriate to take into account as part of the overall assessment that it may be required to make. We do say, however, that because of the extraordinary nature of the inability to terminate in any circumstances, it shouldn't be necessary to go into that kind of nuance.
But just to press you, when you say the principal thing, the principal thing are features of a trademark license which one might expect to see elsewhere and the inability to escape it. Do you add to that features of a trademark license that one might not expect to see elsewhere? Because if you do, we have the problem that my lord is adverting to. And if he feels under some difficulty in that respect, it is, if I may say so, in my case, multiplied manyfold.
What my lord is pressing me on is, as it were, my fallback position, because my principal position is one doesn't need to look at any of this to see that we're right. The fallback position is, well, suppose the court is of the view that it's possible that a contract which commits us in perpetuity is reasonable, or is capable of being reasonable. What further factors does one look at and how does one assess them? And we stand by the submission that these provisions are one-sided. Can I prove that such one-sided agreements are not common and consequently not to be treated as part of the trading society? I can't prove that, but do I need to? My submission is I don't, for two reasons. First, drawing, of course, on the observations of late Justice Carr in the quantum actuarial case, the trading society test is not to be seen as a strict definition. It is simply of assistance, so one should not apply it to a point at which the result may be perverse. But perhaps more importantly, because the burden in relation to the trading society test, if one is to apply it, is on the person who is going to seek to rely upon it. And I don't need to rely upon it. All I need to do is to allow for the possibility that it could apply to an ordinary trademark license. I don't need to rely upon it because it is simply part of the triage exercise which one allows the court in an appropriate case to dispense with the need to assess the agreement from the point of view of reasonableness. And it's, of course, no part of my case, certainly not necessary for my case, to say that there are any circumstances in which it might dispense with that assessment.
I'm sorry to keep pressing you, but I'm just trying to get clear in my mind what really matters. We've looked at clause 5 and what effect that has, and that's really what you focus on for what constitutes the restraint in practice as to the way that conduct the business. And you say that might be perfectly reasonable, but it's not reasonable if it has to be done in perpetuity. If we just look at the other side of the coin and consider whether there are some things which might, even in perpetuity, be perfectly reasonable. Does one come across royalty cases in which the intellectual property rights are granted for a particular period of time, let's say a year, you publish my songs, but the payment obligation is perpetual. I say I don't want to be paid a lump sum now, what I want to be paid is £100 a year, and it'll go on and benefit my children and grandchildren and forever. And even if there aren't, would there be anything wrong about the payment being in perpetuity in such a case?
I'm unaware of any such case. Both in this context and in any ordinary commercial context, I'm unaware of any such case. Now, there may be circumstances beyond my philosophy, of course, but it's maybe one of those situations, and in the absence of evidence, one always falls back on this, where the court can simply take judicial notice that any obligation in perpetuity is a pretty extraordinary thing, and an obligation to pay money. I mean, it may not be surprising.
I'm sorry to interrupt you, but would it be a restraint on trade in the narrow sense of a fetter on trade within the Diplock, Denning, Wilberforce definition? I'd be quite surprised.
One can,
and of course, in one sense, if I'm not spending my money on something else, it might conceivably stop me spending it in a way which enabled me to trade. It's you in the example, but one would have thought not. So
Lord,
I'm struggling to see that simply because a payment obligation extends in perpetuity, that we're really in the territory of the restraint doctrine.
My Lord, insofar if, in answer to my Lord's question, there are other forms of payment obligation where similar questions could arise. The mere fact that it may reduce your profitability to have an ongoing payment obligation, which could, of course, be wholly independent of the marks you use or the way in which you trade, would not ordinarily be a restraint of trade. It might simply be the product of the terms on which you've borrowed the capital which you've invested in the business. So I must concede that, but at the same time, that's not what we're concerned with here. We don't just have a obligation to pay monies indefinitely. We have it tied to the definitions of licensed services group and group companies in a way which we say has a poison pill effect. So it's not simply that we have an obligation to pay some monies in perpetuity, we also have to have an obligation to pay a variable sum of money where the variation affects the what's realistically open to us as to the ways in which we might conduct our business.
I believe that, just looking at the remainder of my note, that the points that I was proposing to deal with are points that we have in one way or another already covered. So it's with some hesitation that I say, unless my lords have any further questions for me.
Yes, I do. What are you saying about severance? The closing passages of your skeleton argument, I think, deal with this, with Egon, Zender.
Yes.
Because, I mean, I've been turning over in my mind whether this, if you were right, this agreement would ever have been entered into, because one can't tell and there's no finding of the judge whether Dame Zaha would have been prepared to deal with it on your terms. But assume that that's misplaced. One doesn't, as I understand it, simply because you come upon some restraining features of an agreement, just simply bin the agreement. You look to see how the agreement can be saved with least interference, doesn't one? So, I mean, are we not potentially very much in that territory?
My lord, we are potentially, and indeed, I think I touched on this in response to a question my lord asked in the first part of the morning, and I'll endeavour to develop that a little further.
Yes, but I just said, so I can get out of your way, it seemed to me that if you were successful to the point that this was a restraint of trade and that it was unreasonable, the next question that the court, as I understand it, would have to ask is what to do about that. And there might be a number of different ways, because this is an interlocking agreement, in which one might preserve the agreement with surgery to the smallest objectionable content. And so we're going on, are we not, to have your submissions as to what that form of surgery would best be?
My lord, yes.
Unless your submission is the whole thing's got to go, it's destroyed by this restraint.
My lord, that's not our submission. But I need to be a little careful in the way that I put that. In the event that my lords find there is a restraint and that it cannot be cured either by severance according to common law principles or pursuant to the contractual provision in clause 18,
then the contract as a whole is unenforceable. The court will never enforce an unenforceable contract.
I think you've just told us that you're not saying that.
What we are saying is what we have proposed is a potential way of modifying the agreement. My own friend says that doesn't work, and if he's right on that, and we're wrong, sorry, if we're right on that, but the agreement is an unreasonable restraint of trade, that's the end of the matter.
Yes.
But,
Well, sorry, could we just seat ourselves because it may help in the core bundle at page 58. I think it's where you're grappling with this. I'd understood at a high level from paragraphs which finds the 64, 65, and then 66, 3, 2 and 3. That there are various different ways in which one might skin that particular cat.
yes.
So I wonder if you could just help me at least to understand what those ways are and which one you contend for.
I will, my lord. So, first of all, just to outline the principles. If there is an unreasonable restraint of trade and it can't be cured, the contract falls away. How could the restraint in this case be cured? It can be cured either by application of clause 18, or ordinary rules of severance
in accordance with the
Tillman and Egon Zender case. What the court can do in any particular case, what is appropriate to do, will depend on the nature of the mischief that the court has identified.
Could we cut to the chase just for a moment? And what is it that should be done in this? I mean, which bit of the license agreement should be taken out and removed? Which bits or bit?
Well, for example, my lord, if you take clause 12 and you hold that what's the mischief here is the fact that the agreement continues in perpetuity, and if you say that that depends on the proper construction of clause 12, including the language following the comma, one route, depending on how you've analysed the case in the first place, would be simply to cut out that language. That depends on the way that you've construed the document and the significance in any, if any, that you attribute to those terms.
Sorry to interrupt you, but one to cut to the chase as well. So one way of doing it is clause 12, if contrary to your first submission, indefinitely means perpetually, then you should replace the word perpetually with upon reasonable notice, or the language you've used in the pleading, but something to adjust clause 12 to take out the perpetuity aspect.
My lord, yes, that's not something that one could do under the blue pencil test, but it is something that one might do by way of modification under clause 12 of the 18, clause 18 of the agreement.
Yes, leave aside for one moment the route that one gets there.
Yes.
But cutting to the chase, could one not also, as an alternative, leave clause 12 as it is, meaning, on this assumption, perpetual, and delete clause 5,
If
5.1, would that also meet the mischief?
That would meet the mischief insofar as it is the combination of clause 5.1 and perpetuity of which we complain, because it would have broken there would no longer be such a combination.
Why would that not be a more suitable solution?
That by itself wouldn't be a more suitable solution, because it would leave in place the poison pill issue, and it would leave in place the problems with clause 4.1 and direction and control. So if my lords were to take the view that it is only the combination of perpetuity and one of the other clauses on which we've focused that is the problem, then my lords can go on and say, well, could we delete this particular clause without affecting the overall character of the agreement? But it is only in circumstances where that is the sole combination which gives rise to the mischief that would be an appropriate way of resolving it. In a case where we're concerned, as we say we are here, with the combination of a number of covenants under the agreement and their continuing in perpetuity, we say the appropriate modification to make is to the termination provisions.
And the ones you identify other than 5.1 are the clause 6 obligation to pay by reference to the definition of licensed works. Is that?
It was that, and it was also the provision in relation to the taking of direction and control in relation to the conduct of the business from the licensor, which is a combination of, I think, is it clause 4.1 and clause 11.2. I can just
Check that.
yes, it's
It's 4.1.
4.1 and 11.2.
So it's 4.1 and 11.2, 5.1, and of course the royalty provision itself, which is 6.
I'd understood from the last sentence of your skeleton argument at 66.3 that even though it was only your second alternative proposal for the solution to this, that the striking down of 5.1 was considered to be a solution, even if it was only your third suggestion. It sounds from what you've been saying to my lord that the situation is not as clear as that. And I was asking you this question because I wanted to understand better what the practical proposals that you made to resolve any problem that we agreed with you about might be. And are you withdrawing from 66.3, which simply declares 5.1 unenforceable, being unreasonable restraint of trade? Because I understood you a moment ago to suggest that it wasn't just 5.1, but one go to other paragraphs and clauses. They also constituted too much of a
This may depend on the argument which, having heard it from me, you sought to adopt, that clause 5.1 and the other clauses we talked about, including 3.2, involve a positive obligation to develop the marks, and you'd certainly say you need to get rid of all of those.
Yeah.
But that I don't think was on your radar when your skeleton argument was drafted.
My lord, it was not. There is a particular concern
About 5.1, but
in a sense it is, there are a number of concerns we've raised about the agreement, we don't know which, if any, my lords will agree with, without knowing how, where my lords see any mischief lying. It's quite difficult to say which particular solution is the appropriate one. We've endeavoured to identify what may be appropriate solutions. It's certainly better than where we are today as we see it. But at this stage, it may be the most constructive thing we can do, and perhaps we can't go further, is to identify, one, the routes by which any view that my lords take as to where the mischief lies may be addressed, clause 18 and severance. Secondly, the consequences if they can't be addressed, which we've already touched on. And then some of the ways in which that might be done, in particular in relation to 5.1. But I'm not sure that I can, certainly without producing a very substantial array of possible approaches, anticipate where my lords will ultimately determine the mischief lies and to what extent it can be focused simply on individual or clauses of the agreement, or requires one to take into account a significant number of them.
Mr. Locke, I mean, I understand your submission. Speaking at least for myself, I don't envisage this appeal being resolved in 2 stages.
Well, no, of course. And
so, to the extent that you feel unable to make any more submissions on those kind of questions, you will, at least as I say, speaking for myself, you'll leave it in our hands to give a decision which will go all the way and go as far as it needs to go to resolve the dispute.
Well,
appeal.
my lord, then our submission is that it should be possible to amend the language of clause 12.1 to address the question of perpetuity, as my Lord Justice Popplewell put to me, not under the common law principles of severance, but under clause 18 as a modification. Secondly, that the addition of express language to clause 12.3 as proposed in our pleading is another way of achieving the same objective by way of modification. Thirdly, if the court sees the mischief as best addressed by the deletion of particular paragraphs, the deletion of paragraph 5.1 can be effected without changing the character of the agreement as a whole, and therefore, whilst it would be a lot of language, it could be done either under clause 18 or under the general principles of severance, because one can simply draw a line through it. And the same might be applied in relation to other provisions such as 4.1 and 3.2, where one gets to the provisions of clause 6. It is potentially more difficult because one is affecting the consideration here, the principal consideration, the royalty. But as I believe it was my Lord Chancellor put to me, one might do that simply by removing the references there to group and group companies, or potentially by removing the language of but not limited to in the definition of licensed services, so that any royalties were only payable on the use of the mark. So there are ways in which it can be done. All of those are ways which we would submit it would be proper to resolve this problem, depending on how you define the problem in the first place. And first and foremost of them, we seek a variation in relation to the termination agreement, or a severance or modification to that effect, should it be necessary. Does that answer my Lord's question?
Does mine. Thank you very much, Mr.
I could have 10 seconds. My Lords, a convenient place for me to start is by reminding your Lordships that the company has no desire to stop using the Zaha Hadid trademark. So the company made clear in correspondence at the beginning of this dispute that it wants to use the name under licence from the Foundation in the long term. And Mr. Walker, director of the company, confirmed in oral evidence at trial that that remained the position. The company simply wants to negotiate more advantageous terms, and it's using this litigation as a lever for those negotiations. The evidence references for what I've just said are in our skeleton argument at paragraph 27, if you want to look them up in the supplemental bundle. My Lord, the reason why they want to continue using the trademark is because of its value. And it's important not to be misled or to make a mistake about the fact that Dame Zaha herself is dead. Consider, for example, Ferrari. There once was a man called Enzo Ferrari, who was a famous car manufacturer, but now the name Ferrari is of great value because Ferrari itself is a renowned, prestigious company making motor cars. It's the same with the name Zaha Hadid. The evidence in the supplemental bundle at tab 14, page 200. If you're in the top left-hand corner of the transcript, Mr. Walker is giving evidence. I put to him that in the world of architecture, Zaha Hadid has two meanings. First of all, the name of a late celebrated architect who died in 2016, yes. And secondly, it's also the name of a top-tier global architecture firm that continues to be known for its innovative work around the world, yes, correct. So somebody embarking on a major building project who's thinking about hiring an architect, when they see the company name Zaha Hadid Architects, they'll probably know Dame Zaha herself is no longer with us, but they will also know that Zaha Hadid Architects company still provides world-class architecture services around the world. And the judge himself, in his judgment, made that if you go to the the company's website, the first thing you see is a big picture of Dame Zaha. It's paragraph 69.
Just go back to your first point. Sorry to interrupt you so early in the piece.
Yeah, please.
But how is it relevant to a question of construction of this agreement? The current position is the company wishes to continue to exploit the marks. Don't we have to test it by circumstances which might arise where they didn't?
Absolutely. But one of the points my friend makes is, and I think he uses the word absurd in his skeleton argument at least, it's absurd for the company to be bound to use the name Zaha Hadid in perpetuity, and yet the company wants long term, whatever that means, to continue to use the name. And the point I'm making is that it is in no way absurd for the company to want to continue to use the name indefinitely, in perpetuity, notwithstanding that the individual from which the company takes its name.
Well, you use indefinite in perpetuity, but you say it's not absurd for them to want to use it forever.
Indefinitely, yes. Yes.
In all circumstances that might conceivably arise.
Yes.
Even should some huge opprobrium start attaching to the name because what's discovered about her in different a different climate in 100 years' time, or because the buildings fall down and there's a great catastrophe, or in any foreseeable circumstances, it's absurd to suggest that they wouldn't still want to be associated with the Zaha Hadid name in those circumstances.
I don't know. So I don't know if I got. Yes. So I'm not saying it would be absurd to suggest that they wouldn't. I'm saying I'm meeting the case again because I don't need, because the contract says in perpetuity, and obviously I'll be going to that. What I'm dealing with is
it says indefinitely, but assume it means forever.
Yeah.
Assume it means forever.
Yes, indeed. I'm dealing with the argument. I'm dealing with the argument the other way around. It's not absurd for the company to want to use the name in perpetuity.
But what I'm putting to you, it is if in perpetuity means in all the circumstances I've been discussing.
Yes.
If what you're saying is it's by no means absurd that they might want to use it for the foreseeable future, I understand what you're saying, and you say here they do at the moment, but that may be a question of what amounts to a reasonable period of notice, not whether indefinitely means literally forever.
And your lordship has put some, and I don't mean this disrespectfully, ingenious possibilities as to why the name Zaha Hadid could become tarnished. But the reality is, the only way that the name Zaha Hadid is going to become tarnished is through their activities. They are Zaha Hadid, and what the name means is them, is the company.
What happens if one of her iconic buildings collapses? Might that not tarnish the association with the name?
Well, if a Ferrari crashes or goes bad, Ferrari wouldn't want to change their name to a different name. I mean, this is speculation. My point is no more ambitious than reminding the court that the position is that they want to use the name going into the future in the long term, and therefore it's in contrast to the suggestions from my learned friend. This is somehow a bind on the company that they're straining under the yoke of having to call themselves Zaha Hadid, which is by no means the factual position. My lord, so with that reminder, as it were, I'm going to go straight to the construction issue. On the construction issue, I'm going to address you, your lordships, under three headings. Those are the three headings in our skeleton argument, paragraph 7. So I'm on page 60 of the core bundle. I've tried, with what success will be for your lordships to judge, to link the headings to the grounds of appeal. But essentially, ground 1 is the wording of clause 12. Sorry, heading 1 is the wording of clause 12. My second heading is Mr. Block's 3 old cases. And the third heading is the factual matrix and the company's arguments about absurdity. In terms of the law, I'm not proposing to address your lordships on the well-known modern cases on the interpretation of contracts. We've name-checked key ones at paragraph 8 of the foundation skeleton argument, both Supreme Court authorities referring to other Supreme Court authorities, and Sir Geoffrey Voss's summary, which I personally find very useful in La Misa. So my first heading on the construction issue is on page 60 of our skeleton argument. This relates to the wording of clause 12, and it's where I deal with the company's ground 2. So we say, in agreement with the judge, that the only possible meaning of clause 12 is that the agreement will continue unless terminated in accordance with one of the modes of termination expressly provided for in clause 12. And there are three...
I'm sorry to keep interrupting
Yes.
you, but putting it in those terms, which simply recites the clause but deletes the word indefinitely
Yes.
and deletes the word earlier, does that suggest that, on your argument, the words indefinitely and earlier are superfluous and surplusage?
No, I see why you say that. No. Earlier I'm going to address expressly, and your lordship put the point that I'm going to make to my learned friend, and your lordship was absolutely right, which is there's nothing wrong with saying continue forever unless terminated earlier. On indefinitely, I was avoiding the word indefinitely because my learned friend and I disagree about what the word indefinitely means.
No, but I'm putting a slightly different point to you.
You know, I do understand that.
Which is, you
The answer to
don't take them individually, but if you didn't use either of them, you say it would mean what it means.
yeah, that's one
And
point.
That does suggest to a common contract lawyer like
Yes.
that you're treating them as surplusage and
No.
unnecessary.
No, I'm not treating them as surplusages. I put it that way to postpone, not avoid, postpone the debate about the words indefinitely and earlier, no more than that.
Well,
But I do
it's
see
perhaps
your
unfair
point.
of me to
No, I do see
tie
your
it to
point.
paragraph 9 of your skeleton, but
No, no.
the substance of the point remains. If you crossed out those two words, I think it is your case that it would sufficiently say what you say it means.
Yes, yes, it would. Yes, it would. But and I would never want to lock horns with a proper contract lawyer such as my lord. But
I didn't say proper, I just said.
well, compared to me, but redundancy is not something which never occurs in contracts. The example when we were discussing this at lunch, the immediate one was put to me was cease and desist, because the words cease and are completely nobody could think of any circumstances in which the word cease and added anything to a cease and desist letter, which is perhaps more in my field. So lawyers love using more words than are absolutely needed, especially when writing contracts. And we see it again with, and your lordship pointed this out, expiry and termination. I mean, this contract doesn't provide for termination, and so it could just have said termination. But lawyers just love writing.
It doesn't provide for expiry.
It doesn't provide for yes. Sorry, did I say termination? Yes, sorry.
I mean, one could give meaning to that. Expiry is often used to mean by a fluxion of time, but it needn't necessarily do so. It might expire by any common law method, such as frustration. So
Indeed.
that's not necessarily.
No, frustration. Frustration is a possibility. I don't want to get into this, but it's probably possible to imagine a situation where that could happen with this contract.
But I don't cavil with the proposition that it's not unusual to find surplusage in contracts.
Yes, indeed. And this clause is not the only one where you definitely find it in this contract. Let's focus on the three aspects of clause 12, which make it really clear that this is the only possible construction. The first is the structure, and this is what I call the A unless B structure. So you've got a state of affairs, A, which is it continues indefinitely. You've got an event, B, and the clause is A unless B. And that means that unless event B occurs, state of affairs A will obtain. And it's just on that, by way of footnote to that submission. Remember, it's common ground that the words at the end terminated earlier in accordance with clause 12. They refer to clauses 12.2 and 12.3. So B is terminated in accordance with 12.2 and 12.3. So the structure is, it will continue indefinitely. That's the state, that it won't come to an end, it will continue indefinitely. The word continue is at least as important as indefinitely, unless terminated by 12.2 and 12.3. So that's the first point on the wording. The second point, the second aspect of clause 12 is the final words of 12.1, unless terminated earlier in accordance with this clause 12. And that makes clear that all modes of termination of this contract are express. So it's saying the modes of termination are set out in this clause. In this clause 12. The third aspect.
So I just
Yes.
pause there. It is, as you rightly say, A unless B, B being termination.
Under 12.2 or 12.3.
Exactly. How does the fact that B involves termination under 12.2 and 12.3 tell you anything about what A means?
Oh, I'm now. No, it doesn't. It just
Well,
tells
I thought your point was, but I misunderstood it, that A can't be dealing with termination
No,
because that's what B deals with.
no. What my point was, if 12.2 or 12.3 hasn't happened,
Yes,
then A must be the state of affairs.
yes, I understand
And
that.
A is continue indefinitely. I'm underlining continue.
Yes,
If the company terminated by giving reasonable notice, then the contract would not continue indefinitely, and yet 12.2 and 12.3 had not occurred. That would be a situation where A stopped happening, it occurred.
I mean, I understand the point. It's A unless B, and you assert, and we'll have to come back to this, that what A means is perpetually.
Well, but
But what I was not understanding was what you get out of your second point, which is B are express references to termination. It's my fault. I'm just not seeing how that helps you.
if you don't mind, I want to go back to the way you paraphrased A. What you said, what your lordship said was A means perpetuity.
No, I said I understand that to be your case.
Yeah, sorry. A is continue indefinitely.
Yes,
Continue.
yes.
So if 12.2 and 12.3 don't happen, then the contract must continue.
Yes, and the question is for how long? And you say indefinitely means literally
Indeed.
forever.
But
And
the
that's
word
what we've got to grapple with.
indeed, but the word unless means that it will continue. It isn't continue. If my learned friend is allowed to terminate on reasonable notice, then imagine the situation where he gave reasonable notice. Then the contract would not be continuing indefinitely. A would cease to have. We would be in a world where A was not happening, but B hadn't occurred.
Well, it depends what A allows. If it said, which I think is the equivalent for your structural points, this agreement shall continue until 2050, unless terminated earlier in accordance with this clause 12, then it would still be continuing until a point of time, and in that case, the point of time would be identified. In this case, what is said is it shall continue indefinitely, and really the construction issue is, does that mean until the crack of doom, or does it mean until some undefined point of time, but which can be earlier?
All right, well, you have my first submission, and the A unless B does suggest that B has to happen. The second aspect is that the final words of clause 12.1, unless terminated earlier in accordance with this clause 12, they indicate an intention that clause 12 will provide expressly the modes of termination, and that point is then goes with and is reinforced with the presence and terms of 12.2 and 12.3, which is my third point and may be my best point. The existence of 12.2 in particular makes the company's argument really impossible. As you know, this expressly gives the licensor the ability to terminate without cause on giving several months' notice, and the agreement doesn't give that ability to the licensee. And anybody reading that would see that this is intentional. The parties couldn't have made it clearer that it's the licensor and not the licensee that has the ability to terminate on notice without cause. And it would be wholly inconsistent with the existence of 12.2 as to construe 12.1 as itself giving an ability for both parties to terminate the agreement on notice without cause, which is what the company's case has to be.
Because you say there are no circumstances in which it would be reasonable to expect the licensor to have wanted to terminate without cause, without these causes, within a shorter period than 3 months.
It's perhaps possible, but given the presence, I mean, if the contract had said 2 months' notice, nobody would say, well, throw their hands up and say that's absurd. What my submission on that is given the presence of 12.2, it would be wholly unreasonable for my clients to claim the ability to terminate without cause on 1 month's notice. That really would be absurd. If they were to come, if I were to come to court and say, I gave notice 1 month ago, and now I want an injunction today to stop them using the trademark, the court would say, no, you have to give 3 months' notice. Now I said, oh, no, but I can give reasonable notice as well. I can give 3 months' notice, but I can also give reasonable notice, and I want to now explain to your lordship, your ladyship, why only 1 month is reasonable. The judge would say, no, you've agreed. If you terminate without clause, you give 3 months' notice. It's absolutely clear. Anybody, the company can see clearly that as long as 12.3 doesn't obtain, they get a minimum of 3 months' notice, and that is my answer to that question. When I say that the existence of clause 12.2 means that it's impossible to say that the licensee also gets the right to terminate without cause on notice, of course that's the so-called expressio unis principle, and that's very helpfully summarised in Sir Kim Lewison's book, which we've got in the authorities bundle, and I've also referenced it in my skeleton argument, paragraph 13. So you can see if you've got my skeleton argument open at page 61, you can see how it's put in that book. That extract is in the authorities bundle at tab 31, and it's, as if I may say so, the Lewison book, if I may call it that, extremely helpfully always gives the principle and then has very helpful and apposite quotations from the case law. And so the section we've referred to there, paragraph 7.53 following, sets out quotations from the case law, but it's a well-known principle that has this Latin tag, which Sir Kim Lewison expresses in the way I've put it, I've quoted at paragraph 31.
I'm looking at footnote 504.
Yes, I'm going to come to footnote 504.
You better come to that.
You're looking at footnote 504, and that's in a different section, isn't it?
No, at the bottom of the page.
Yes, so the page, let's go through it. So the
Sorry, I
page,
don't want to take you out of your course, but it's just that there's some thinking there about construction and implication.
yeah, indeed, and I'm going to address footnote 5. I'm going to address footnote 504. The page that I'm drawing your attention to now is in the bundle, page 1062. Yes, thank you. So I'm drawing attention to 1062 and the quotations, the first three quotations, actually all of those quotations on those 2 pages are extremely apposite and helpful and directly relevant to the submission I'm now making. My Lord, the only other point on the wording is, of course, the word earlier, and I've already made my submission, which is simply to adopt what your Lordship put to my learned friend, which is what I put in my skeleton argument, which is that no businessman or even a lawyer would have any problem with earlier than forever. Something will continue forever unless something else happens earlier. It really is as simple as that.
Can I suggest to you there is another question on the wording?
Yes, absolutely.
Which is what the meaning of the word indefinitely is. If I say I propose to emigrate to America and stay there for as long as I like the particular persuasion of the president, I might be said to be intending to move there indefinitely. That is not the same as saying I intend to move there permanently or in perpetuity. What the word indefinitely means as a matter of normal language is not forever, it is for a period which is not here defined.
So I completely agree with that, subject to, I completely agree that the word indefinitely, contextually, just taking the word indefinitely, contextually has that meaning, but which includes the possibility that it means forever, that when you say, and let me be precise, the word indefinitely can mean forever in the correct context. In this contract,
Well, you say that.
Yes,
Can you show me an example of whether it's ever where it's
Yes.
ever been interpreted in that way?
oh, interpreted that way. I thought you were going to say, give me an example where it's used that way, which is
Well,
12.1, we say can only mean that. And the reason why you know that is for the 3 reasons I've given, most significantly because of the because of the references to in 12.2 and 12.3, giving a party the right to terminate without cause on notice.
I understand your point.
Yeah.
I understand your points on that. But just coming back to the word indefinitely, which in a sense one might think is the starting point rather than the finishing point. I've put you a sense in which it doesn't mean, actually.
Yeah, absolutely, and I accepted that.
Are you aware, either by way of an example you can give me in common language, or better still from your point of view, some authority in which it is properly to mean literally forever?
Not off the top of my head, and I don't want to make up an example which will, without properly thinking about it. I'm certainly not aware of an authority. I rely on the context of 12.2 to show that that's really the only thing that it possibly can mean.
But if as a matter of language, it doesn't mean forever. It simply means until some point in time, which we haven't defined.
That doesn't. Sorry, I don't want to interrupt. But that doesn't. That's not a problem for me, because as long as it means, if it means until some point in time that we haven't defined, that's absolutely fine for me, because the question is not, is there any other way in which the contract can come to an end? We talked about frustration as being a possibility. What matters is one of the ways it can come to an end, or is a way it can come to an end, termination without cause by the licensee. And clause 12.2 tells you absolutely clearly that whatever indefinitely means, whatever the possible ways in which this can come to an end, termination licensee without cause is not one of them, because it would be there. They've put in 12.2.
I understand that submission, but if forgive me for pressing you on this, but you can see it's what's troubling me about this aspect of the definition. If undefined doesn't mean forever, it means until some point of time. And we're talking about contractual rights of termination here. If it means until some point of time, doesn't one, either as a matter of construction or implication, leave aside for the moment which it is, have to answer the question, until when? And what's your answer to the question, until when?
Well, indefinitely doesn't mean that it definitely will come to an end. There may not be anything which in the course of events can come to an end.
Really? Until the world ends?
No. What I mean by that is
it will definitely last until the world ends.
It doesn't have to be. No, what I mean is indefinitely.
Isn't that your case?
No. Sorry, you misunderstand me. I apologise. Indefinitely doesn't have to mean in perpetuity. And your Lordship gave an example of moving to America indefinitely. But when you use the word indefinitely, one thing it doesn't mean is it doesn't necessarily mean that there is anything that can bring it to an end. It's not, the word indefinitely in your example didn't rule out the possibility of you coming back to the United Kingdom, but it doesn't necessarily mean that there necessarily is something. I have given, this is true, I've given up playing 11-a-side football indefinitely. Now, I challenge anyone in here to come up with a situation which I'll go back, a realistic situation which I could go back to playing 11-a-side football. But it's a perfectly good use of language for me to say indefinitely. I suppose it doesn't, although it betokens no particular even necessary return, it doesn't mean that there is anything, doesn't necessarily mean that there is anything that will make you return. If you said, I'm moving to America indefinitely, is a good example of a case where you would say, well, then I bet I can think of circumstances which would make your Lordship return to the United Kingdom.
But is it a question of whether it will necessarily come to an end?
That's my point. It doesn't necessarily mean it will necessarily come to an end.
But if what indefinitely connotes is that there are circumstances in which it won't last forever, then we have to ask the question, what are those circumstances as a matter of contractual termination?
Yes. So Well, hang on, the three.
That's the point I'm putting to you.
Yeah, so I've made three observations, only the third of which is answering your question. The first is, I've not accepted that it means that it necessarily could come to an end. It just means we're not ruling out that. Secondly, if continue indefinitely means, well, it must be able to come to an end, that doesn't necessarily require that mean of coming to an end to be contractual termination. We mentioned frustration, for example. It's perfectly possible that one possibility would be that continue indefinitely means unless it comes to an end by some operation of law such as frustration. But in terms of contractual termination, the only methods of contractual termination are in 12.2 and 12.3. The word indefinitely definitely doesn't mean there must be some way of it coming to an end by contractual termination. The worst that could be put against me is that the word indefinitely connotes the possibility of the contract coming to an end somehow, and there are obviously other ways in which a contract could come to an end, but contractual termination, the company being struck off the register of companies, for example, would come to the contract would be at an end at that stage.
Would it?
Oh, okay. I'm now way out of my comfort zone. I don't know.
I mean,
I assume so.
Of course, it would be incapable of being performed, but at that stage,
I think it would come. I think it would come to an end at that stage, my lord. I don't know. I'm not the person to ask about. Might ask the head of the Chancery Division what the answer to that question is, but certainly don't ask me.
How are we in for time, Mr. Abram?
Oh yes, I mean that's a convenient moment because I was going to move on to my second heading if my lord had finished torturing me on my first heading.
Very well. 10:30 tomorrow.
Court rise available.